All right. Aloha, Nick Dranias. We've got Nick Dranias here from Compact for America and the Goldwater Institute. Let's start out, Nick, by explaining to everybody who you are and what I think a lot of people, especially in Occupy, would be really interested to find out is how you kind of fit in with the Citizens United story. Kind of fill us in there.
Well, Dan, first of all, thank you. And you know, I may come on the other side of the ideological spectrum than many folks in Occupy, but not on all issues. I think we share a common interest in being concerned about the concentration of power and also corporatism, the combination of business and government. And we have different approaches, though. I think my preference is to divide up power to minimize power. I think the general approach that folks on the left take is to look at the monetary influences, and I tend to think that is more of a symptom than a cause. For me, you break up the power, you decentralize the power, you control the problem. But that being said, I'm at the Goldwater Institute. Now, this is named after Barry Goldwater, the senator that started what I believe is principled conservatism. Now,
let's get back to that, though. Let's finish that question, because I'm a little bit curious about how you fit into the Citizens United story, because I know that you defeated the Clean Elections Act in Arizona, and it seemed like a lot of those the arguments that were the basis for Citizens United were basically your arguments. It seemed to me, I might not be correct about that, but it seems like you do have a crucial role in that story.
Well, I think I don't want to overblow it. I mean, we filed a friend of the court brief. It was a case that we did not directly litigate, and it was actually my predecessor, Benjamin Barr, who wrote the friend of the court brief. Now, that being said, I believe in the outcome, and I believe in the reasoning, and the argument is simply that the First Amendment does not allow for any infringement on the right of free speech, and the use of money to engage in expressive activities is an unavoidable reality. I mean, you can't have newspapers without printing presses. You can't have printing presses without the ability to buy them. Money and speech are intimately intertwined, and so you have to just recognize that spending money to project your message is just as important as the message itself. And in terms of the corporate influence, in my view, corporations are simply organizations of individuals, and just as a union doesn't lose its First Amendment rights because it happens to be a union, the members of a corporation don't lose their First Amendment rights if they join and form a corporation. Now, in the end, for me, I'm not afraid of speech. I'm not afraid of engaging in the realm of ideas. That's why I'm engaging with you, Dan. There's a lot of folks on the right that would kind of treat you guys like the Invasion of the Body Snatchers and just go, but I believe that someday I'll persuade you, Dan, and I'll persuade most of the people listening to my point of view. It might take decades, but I think that with enough speech, I can win the argument. And I think if you have confidence in your own beliefs, then I think you shouldn't be afraid of more speech, even more speech by people you loathe, because in the end, the truth wins.
Right. I think you make a great point. It is definitely one of those issues where it is a slippery slope. It's very complex. If we're going to talk about these kinds of things, we need to really understand what the ramifications are that we're talking about. And I definitely understand where you're coming from. Where you say that the First Amendment, we can't limit the First Amendment. When I look around, I see basically limitations of the First Amendment wherever I look. The right to peacefully gather, it seems to be infringed all the time. It does seem like there's definitely limitations to it. Also, whether corporation is domestic or not, to me, is a whole other issue that seems to be almost a vulnerability in our system. So, but I don't want to spend all this time talking about Citizens United. I want to get to the Compact for America. First of all, let me tell everybody out there, get you a little bit more familiar. Article 5 of the Constitution explains how 2/3, or right now 34 states, need to apply to Congress for a convention to propose amendments. Our group and Friends of Article 5 convention that you know of have looked at over the history of these applications. We've seen basically every state jump into the application realm, and over 700 applications. And Nick, I wanted to ask you, you've done a lot of work looking into Article 5. Do you think that that Congress, their role in this is to be a guardian or a clerk of these applications? Are they preventing America from having this convention?
Well, there's a difference between what is and what ought to be. I don't think there's any question that the state origination of constitutional amendments through Article 5's application process was meant to be parallel to Congress's power to originate constitutional amendments. It was supposed to be the check on Congress's power and to provide an alternative venue for seeking constitutional reform. And if that's what you view this process to be, it makes no sense to regard Congress's role as anything other than a ministerial, clerical type of role. Because what's the point of having the state origination of constitutional amendments as an alternative to the congressional origination of constitutional amendments if Congress is the gatekeeper at both ends? So from a originalist point of view, an understanding of the Constitution as it was meant to be interpreted and understood and applied, which is what I subscribe to, I just think it makes no sense to view Congress as having any significant role in the state origination of constitutional amendments under Article 5. Now, the reality is that Congress does have a role. It has to call the convention in response to the applications, and then later, assuming the convention generated anything, then Congress would have to refer out that proposed amendment for ratification. So in practical reality, as a matter of power politics, there are 2 points of leverage that Congress has. And so even though Congress's role should be no different than that of a secretary putting something in an envelope and dropping it in the mail, the reality is they have an opportunity to try to exert power illegitimately. And in the end, I think the hard question for Article 5 movements is how do you generate the political will, the political threat, or the carrot, the political carrot that would result in Congress standing down instead of corrupting the process, instead of obstructing the process. How do we make sure that Congress does what it was supposed to do, which is simply act as a secretarial, ministerial type of entity? And that's really what I think the Compact for America achieves. It finally masses political will in an immediate and concrete way that will strongly incentivize Congress to play by the rules, both as a carrot and a stick.
Great. Now, a lot of people talk about this convention, and there's a lot of fear surrounding the convention. A lot of this originates with Phyllis Schlafly and the John Birch Society. They say things like the convention will tear apart the Constitution, the very fabric of our nation will be altered, and we won't have any control over it. Do you believe that these fears are founded of an open convention, not the Compact, but the fears of an open convention are founded in reality, or do you think that there's safety mechanisms in there that keep it from basically becoming the runaway that they talk about?
Okay, here's the bottom line. For 2.5 years, I've been battling to get a regular Article 5, of what I call plain vanilla Article 5 application passed in about 20 states. And if it wasn't for the John Birch Society and the Eagle Forum's opposition, which is incredibly strong in red states west of the Mississippi and in the South to some extent, and actually, they're everywhere.
Yeah.
I mean, they're strong in Indiana, they're strong in Ohio, they're strong in Missouri, they're strong in Kansas, Arkansas, Idaho, Utah, even North Dakota, although we beat them there. The bottom line is this. I was in 20 states, physically or virtually. We did everything we could to pass what we thought was a very important idea, which is to restrain the federal debt by having states approve any increase in the federal debt, take it out of Washington, make it more decentralized. We thought it would be, very, very salable to state legislators who would, after all, be getting a little bit more power and a seat at the table in Washington. We only succeeded in 2 states. We only got passage of this idea in North Dakota and Louisiana, and there were many occasions where we had committed votes flip out on us because of the presence of, on the Eagle Forum side, usually grandmotherly and very upset people on their feet in the committee room. And on the John Birch Society, sort of the flip side, a lot of grandfatherly and very upset people at standing room only in the committee room opposing me. And that proved very persuasive and incredibly difficult to overcome. And so instead of getting to 15 or 16 states, which I think we could have gotten to in 1 or 2 years, we only got 2 states. And it was their opposition at the committee level, and basically packing rooms with grandma and grandpa times 10, all upset, many times crying, just terrified about the end of the world coming and the Constitution being thrown out the window. Now, for a long time, I kind of looked at that as if these folks were, a little bit off the rocker, and that's how I tried to approach it. I tried to overrun them. I tried to overpower them. I tried to get on more media. I tried to get on. I tried to go to the tea parties and confront them head to head, and more often than not, I could persuade more people in the room to our side than would be leaving the room against us. But it wasn't enough. And so after 2.5 years of that, I said to myself, okay, what do we do about this? I'm not beating them on the ground, and life is limited, and the time is ticking shorter and shorter for our country. So what do we do about this? And so I paid a little bit more attention. And I studied the famous 20 questions that Phyllis Schlafly generated about the logistics of the process of Article 5. Who would be the delegates? Where would it be? How would you limit what they would vote on? What would the quorum be? Would there be committees? Would protesters be allowed in the room to disrupt proceedings? All sorts of things like that. And I said, okay, well, what if we could actually answer all of those questions concretely? What if we could call their bluff, if it is a bluff, or show them that they can have answers to these questions? And the same thing with the John Birch Society. They often say that the convention has inherent sovereign power, independent of the Constitution and independent of state and federal law, that can just rewrite everything from the ground up, sort of like a coup d'etat. Right? So that's what they believe. But what if I didn't have to try to persuade them away from that belief? What if instead I could accommodate it? What if I could say, okay, you go ahead and keep believing that, but I've got something here that could still make you feel safe? And so what I did was I devised the idea of using an agreement among the states, which is called an interstate compact, to lay out all of the logistics, all of the procedures, everything in advance by agreement among all the states that would be applying to Congress for a constitutional amendments convention, and also containing provisions that indirectly target that process to whatever constitutional amendment you want. So if you want a balanced budget amendment, or in your case probably something to repeal Citizens United or overturn it, what you could do with a compact is you could prepackage the constitutional language that you want, and you could design this so that directly and indirectly you control the process to allow only for a debate and an up or down vote on that issue. And I believe I've achieved that, and I've got a PowerPoint where I could walk folks through if you want to do that, but or I could take questions on it. But the bottom line is this: 2.5 years banging my head against the wall made me realize that if I can't beat them, if I can't overpower them, can I accommodate their beliefs? Rather than, it's kind of, this is maybe something people on the left already understand better than people on the right. I have to almost have sort of a tolerance for their view, right? I almost have to be kind of multicultural in a way, and say, okay, well, let's just take for granted that they have these beliefs. How do I navigate them? How do I address all of the reasonable or semi-reasonable points that they may have, and constrain the Article 5 process in such a way that we can peel off all but the truly lost people to our side, so this is why I hesitate. 2.5 years ago, I would be ripping on the JBS even more than I have. I'd be tearing into Phyllis Schlafly and Eagle Forum and calling them cowards and so on. I was wrong, okay, and you're wrong if you do that, because here's the thing: a constitutional amendment process is serious. It's a serious process. And it is troubling, reasonably so, to many people who don't have the risk tolerance that you and I do, to not have any advanced idea of what the process is, right? I mean, the only thing we know from the Constitution is that 34 states apply, Congress calls, convention is had, we don't know what the convention looks like, where it is, how it votes, who goes, right? A lot of people are uncomfortable with those unknowns. And I had to eventually come to the humility of recognizing that that is not a crazy point of view. It's not my point of view. They have a greater intolerance of risk than I have. I will trust that if you get 34 states behind something, that you're going to have enough political will that the process will sort itself out, right? But there are some people who don't agree with that. And you know what? Maybe one time out of 10 they'd be right. And if that's the case, why not accommodate that? Why not, find a way to bridge their belief system with ours and their risk tolerance with ours? And I think that's what the compact did. So today I'm a more humble man in that regard. I still think they're wrong, but I recognize it's sort of, they like vanilla, I like chocolate. They don't want any risk. I'm willing to tolerate a lot of risk because I think that the risk of doing nothing is far greater. But nevertheless, they're not outside of the realm of reality. They're not outside of the realm of reason. And because they're not, and because they're powerful, because we can't beat them, at least not in the near term, we need to reach out to them. And I think that I've created a way of doing that.
Yeah, I definitely think that you've addressed every single one of their objections in your compact. And I think you kind of reverse engineered the compact to address their arguments. And again, it is a risky proposal, and you've rationalized that as the status quo, maintaining the status quo is probably more risky than doing that. But you don't personally have anything to fear from an open convention. You've kind of seen over the horizon. You see that it takes an agreement of 66% of the states. And actually, that's one of the things I really like about your vision of this, too, is that each state equals one vote. And that was left, that there's some questions surrounding that, but that's one view that I personally have, that it seems like it should be like that. And I think that's an important aspect of the convention, just because if a state realizes that it's still just one vote, it doesn't need to worry about sending 3 delegates. It could send 100 potentially, and have a larger jury pool, I guess, of what's going on there. And I think you're going to end up with a much better result if you include more voices in the convention. But you particularly don't have any strong fears. You've told me exactly what you expect to see coming out of a convention. Does any of it really concern you as a threat to your ideology?
I'm not worried about a convention because the process, look, I want to be humble about this. I am personally not worried about an Article 5 convention without a compact. But I recognize now, after 2.5 years of beating my head against the wall, that other people can reasonably feel differently. But I'm not worried about it, and here's why. There is the ultimate backstop of 38 states needing to ratify whatever it generates. If we're at a point where 38 states will ratify a crazy idea, the last place we're going to find that happen is through the Article 5 process. It will have already become law in our cities, our counties, our states, and in Congress. It will have already swept the nation because it's so much easier to pursue every other ordinary way of enacting laws than to use Article 5, that if we were at a point where crazy ideas with no consensus that divide and create civil wars, if we're at the point where that could reach 38 states, we would already be there. It wouldn't even be a debate over Article 5. So that's ultimately why my taste, my risk tolerance is such where I don't think there is any real risk to the ordinary process. Nevertheless, using a compact actually makes the process easier for us to use than without a compact, and at the same time gives all the specific answers to all the logistical questions that our opposition has in using the process. So I say, why not? I mean, look, if we can do the process easier and we can satisfy most of the folks out there who are just don't tolerate the risk we are willing to tolerate or have a different sense of the risk, why not accommodate that? So that's why I've devised, with the help of many others, the Compact for America organization has a board of advisors that has a number of other experts involved, and they've given ideas, and we've also vetted the idea. But the bottom line is if we can use a compact and we can neutralize the fears directly, and we can make the process easier to use, why not?
Yeah, it does seem to be a vehicle for basically any popular amendment, any popular idea could basically fit into your compact model and push its way through the states. Now,
if I could just break in there really quick, just to clarify, what the compact does to the Article 5 process is it makes it like a ballot measure for state legislatures and governors. So that the way to think of it is just as if you're in California or you're in Arizona or any of these other states where you have ballot measures. Now these are good and they're bad, right? And they're ideologically neutral. I can use them to advance great ideas on the right. You can advance your own ideas on the left. But these are ideologically neutral tools. The only thing that they do really fundamentally is disrupt the power structure, which in my view, and I think on the principled left, their view as well, is a good thing. Even if we may differ on the particular policies we pursue, I think we all agree that we need something to keep a mix going, and a sort of a decentralization, so that you don't have the power captured in a hand or a class. And so that's why I think most people on the principled right and left support some sort of ballot measure process. But there's other reasons why they would support it. And so what the compact does is it makes the Article 5 state-originated amendment process more like a ballot measure. It makes it easier for the institutions that are relatively closer to the people to wield real power, to disrupt the concentration of power in Washington, and to channel it towards reforms that are necessary to protect our liberties.
And this, you're going for 38 states, not 34 to trigger a convention, but you're actually pre-ratifying the amendment in the compact. You're getting all these states to basically agree to this in advance, and this is going through the legislatures, or is it acknowledging the past applications of all these states?
Well, there are many ways you could do a compact, right? I mean, the key idea of a compact, the one idea that would be the same in any version you do, is that you prepackage all the things that the states do into a compact. So you include in a compact the application, the delegate selection, the convention location, the convention rules, the pre-ratification, the text of the amendment. You put that all into the compact, you bake it into the cake, and the way it works, the critical device that makes it all work, is you use what are called contingent effective dates. They're also known as conditional enactments. They're also known as tie barring. What they do is they make sure that each of these little pieces only go live. They only actually get activated at the right time. So you design the compact so that the application only goes live when you hit the magic number needed for the application to trigger the call. You make sure that the delegates are only appointed when you've got the call triggered by Congress. You make sure that the convention has its rules only when the convention is actually located. You make sure that, so you basically set it up so that you prepackage everything in advance, and you use contingent effective dates to trigger them when the time is right. The advantage of that is, I mean, on one hand, the compact looks like a 10-page piece of legislation, and it is. On the other hand, you only have to pass it once. You see, if you had to do all of those independent stages separately, not only do you have the uncertainty at each stage, but you're basically passing 4 times as much legislation. So from a resource perspective, it's a lot easier to pass a compact, and so that's the route. Now, there's also the congressional component, but we also economize there. what we do on the congressional side is we prepackage both of the congressional steps in one resolution. We actually prepackaged both the call and the ratification referral in the same document. And the way that works is you just have, again, a contingent effective date. The call only goes live when enough states apply to trigger it. The referral for ratification only goes live if the convention generates the amendment that you're contemplating, and if that happens, we don't know if it ever will, then it will trigger the referral back out to the states. But the bottom line is you only go to Congress once instead of twice, and that means you don't have to rely on their good graces twice. Because the reality is, you don't know what Congress is going to do. You know what they should do, but you don't know what they're going to do. So why not just minimize it to a one-time deal? And here's the other cool thing is, with prepackaging all of Congress's activity in one piece of legislation, you can pass that anytime you see the opening in Congress, because it doesn't go live until the right time. So even if you don't have any states in the compact at all, you could, if you saw simple majorities in the House and the Senate, you could try to pass the congressional component and get that done, and then focus on the states. So it gives you a lot more flexibility. It makes it a lot more possible than the ordinary Article 5 process.
Yeah, we've taken a look at everything. I think probably one of the more startling things about the plan is the timeline. You're talking about the first Article 5 convention in U.S. history taking place in July of 2013. That gives us 6 months basically to prepare. And if you're presenting 38 states to Congress, it seems like you've triggered a convention regardless. And whether the progressive side's ready for this or not, if they decide to have honor the compact and allow the states to have this prearranged agreement and closed debate, then that's going to work out exactly the way you want. But if they decide to have an open convention, we on the left are not really prepared for this, and we're going to be caught flat-footed. We didn't want to be caught flat-footed, but the timeline that you guys have here is amazing, and to think that you really have confidence you're going to maintain that kind of pace and do this is amazing.
Well, I want the left to actually see this as an opportunity and not a threat. I don't know if our attitude is not to catch anybody flat-footed. We've designed a reform that I think is a principled compromise on the left and right. It targets the one issue that poll after poll after poll shows that there really is no partisan divide, and that is controlling the federal debt. And we do it in a way that is not ideologically committed to the right. We do it in a way that is, I think, as neutral as the issue can be. And the left should welcome this, because, look, if the left ever wants to use Article 5, there's got to be a first time. And if there's going to be a first time, you've got to use the most plausible vehicle that can get to 38 states. There is no other idea out there. There is no other idea out there that polls the way a balanced budget amendment polls at all. And so, look, if you view this vehicle as a valuable tool for your ends, then you should get behind us, because this is the kind of thing that can get a beachhead. And it's not going to be the first time, or the last time. It's going to be the first time. Once the compact proves itself, just like the first ballot measure, it's just going to be the beginning of more. And you know what? Probably 6 times out of 10, I'm going to disagree with your policies, and I'll fight them tooth and nail. But I don't think the disagreement is going to always exist. And I think the more fundamental thing that would be happening by making the use of Article 5 more regular, more reliable, and just more predictable is that we would serve to decentralize power. We would make it harder for anyone to capture Washington for any significant period of time. And we would cause, I think, in general, everyone to act a little bit more modestly with their power for fear of what they could trigger with a backlash. And I think in the end, whether you're left or you're right, you have to see that sort of détente, or that sort of dynamic check in government, as a positive thing. It may be you lose some in the short run and the medium run, or we lose some in the short run or medium run, but by keeping the concentration of power decentralized and dynamic, I think we prevent tyranny over the long run, which is the ultimate threat to all of us.
Yeah, I have to agree with you there. Anton Scalia mentioned in an interview recently that he believes that the Constitution is dead. It's not a living, breathing document, and this kind of action demonstrates that it is a living, breathing document. We need to resuscitate the Constitution. I've been saying it for a while now. We need a constitutional revival. It was mentioned at the Harvard Constitutional Convention conference that it almost seems that we need to have an amendment at the end of each one of the Bill of Rights that says, "And we really mean it," because of the way we are ignoring a lot of the things that are in there. And I get this a lot too, where I talk about Article 5 and people say, well, I don't really want to change the Constitution. I just want people or the government to obey the Constitution we already have. And it's just not that easy. It seems like we need something pretty dramatic, I think, to kind of make those changes. I've got a question here from Bill Walker. He sent me a question that he wants to throw at you. Don't want to kind of ambush you here with this question, but I'm going to read it to you. Seems like it'll be a good opportunity for you to address this too. He says that in 2000, the federal courts issued the only ruling in court history dealing expressly and directly with the question of calling a convention. That ruling, later affirmed by the Supreme Court, stated that a convention call was a political question for Congress to decide. It used Coleman versus Miller as the basis for this determination. In Coleman, the court expressly and directly stated that Congress exclusively controls the amendment process and has the power, if it was so inclined, to compel ratification of amendments proposed through military force. Given this decision, how can you state that the compact is going to be upheld as legal?
Well, because you have to think about the political reality of what a compact is. This compact doesn't go live until 38 states join it. So you have, and not only that, but we're designing this to go live in 1 year, maybe 2, but we're targeting 1 year. So just think like a practical politician. 38 states binding themselves to a formal institutionalized agreement to wield the ultimate power that they have to amend the Constitution. You think a court's going to stand in the way of that? I mean, even Chief Justice Roberts wouldn't stand in the way of Obamacare. And even if you like Obamacare, you got to recognize what that means politically, right? I mean, the folks in the judiciary are, many of them, unfortunately, are political. And if they see 38 states massed behind a formal legal document, committing them to using this power that they have the right to use, I think suddenly they're going to find a way to be principled about Article 5. It's going to be a lot more realistic politically for them to do that because they're going to see a carrot and a stick. The carrot they'll see is a whole lot of political opportunity in yielding to that kind of supermajority. The stick is, look, in a compact, what is the Constitution? It's a compact, right? I mean, what is the implicit threat of 38 states organizing themselves in a formal compact and then confronting a recalcitrant Congress consisting of what? Not even maybe 12 states, but I doubt even 12 states would want to oppose that. Really, it would be a question of the nation versus Washington, D.C. That kind of political clash, I don't think we're going to see the judiciary siding with the folks in Washington, D.C. any more than you see in a lot of take the Arab Spring or any of these other places where there's tumult right now. The old elites, when they see the wind blowing, they go with the wind. And so the question is, what is the most effective vehicle to bring maximum political will to bear so that those who do hold, for all practical purposes, the keys to Article 5, which is Congress, do the right thing? And I don't think there's any other vehicle out there that does it. I mean, Bill Walker has seen that piling a stack of 100-year-old applications on the desk of anyone in Congress doesn't do jack. And it doesn't do jack because I disagree with Bill on many of his theories, but even if he were right, that's not the point. That's not the point. The point is dusty old applications don't mean anything politically. But a political institution that is reflective of a supermajority of sovereign bodies in contemporaneous fashion, all at one time, that hitting the desk, that staring down, D.C., that is an entirely different dynamic. It is inconceivable to me that in that dynamic you would see Washington buck that, because that, I hate to say it, but that would be a recipe for civil war.
I do think that basically both of you are making the same point. It is going to be a political decision by Congress when it comes down to it. I kind of see it as where you're promoting that the states are going to show solidarity, basically, in delivering this compact. The people also will have a voice in this, and I think that as we approach that, you're going to get these other groups out there like Move to Amend, Wolfpack. There's all these different amendment groups that are going to feel left out, and they're going to say, "Hey, that's our Constitution too. Let us in." And there's going to be political pressure from the people and from the states, and what Congress does with that, it's going to be political. It maybe not based entirely on law. Maybe, I don't know. This is all uncharted territory. So it's who knows? This may only work once. So you had the benefit of being the first one to try it too. So it's let's get back to one other thing too. You mentioned your panel of advisors. And I noticed Larry Lessig's on that panel, and I consider him to be a progressive, but he's over there helping you folks figuring out a way to pass the balanced budget amendment. What's he doing over there?
Well, I wouldn't go so far as to say he's helping us pass the balanced budget amendment. What he's doing is he's making sure that we are respectful to principled people on the left. And he's making sure that the language we use, the policies that we try to advance substantively, are not in a absolute clash or an unreasonable clash with someone who's principled on the left. That's his function. That's what we've asked him to do. And so that I wouldn't want to say that he does more than that. That he made it very clear that his role is to make sure that we remain balanced. And frankly, we would invite many more people from the left of the same caliber to join our advisory council, to give us that same bearing and to make sure that we do continue that way, because we don't believe you can get to 38 states with a hard right or even center right product. You have to have a product that's almost non-ideological, that targets a real problem that everyone who cares about our nation can see. And we think that with the particular balanced budget amendment idea that we have, we've done that. And what makes it different is what we've done is we've said, look, let's have a debt limit, but let's make the debt limit be something that state legislatures control, not Washington. Put 26 state legislatures in the position of basically being the nation's board of directors and approving or disapproving increases in the federal debt. The reason why we think that should apply to the left, that is principled as much as the right, is where are these state legislatures located? They're located closer to the people. Who has the most influence, or at least relatively more influence? The people. I mean, the difference between the influence that special interests can wield in the halls of Washington and what they can do in 26 independent state capitals versus the ordinary citizen, when you can run into your state legislator at the 7-Eleven, is vast. And so if your fundamental belief, or if a fundamental belief of the principled left is decentralization of power to some extent, and I'd like to think that that's still the case. It certainly wasn't the case. It was the case in the 1960s. But if that is a portion of your ideological system, then I think you can see the value in taking away from Washington some of that unlimited power to borrow money and putting it closer to the people and making it harder for that power to be captured by the special interests, which is what goes on every day in Washington. So, and we found that we've done national polling, we've poll tested all of the components of our balanced budget amendment, and we found that we get Democrat support at 50+% for everything in it. So, and that was our goal. Not that Democrats are the left or the principled left, but the bottom line is this: we wanted to have a substantive product for the vehicle. The compact's the vehicle. We wanted to have a payload for that vehicle that shows respect to the principled left, that addresses a problem we all agree exists, that will actually fix the problem, or at least move it in the right direction, and that can plausibly get us to 38 states. Because from my perspective, the balanced budget amendment is only half of the pie. The other half of the pie is institutionalizing the use of Article 5, legitimizing the use of Article 5, showing the world, showing the country that it can be used effectively, safely, and repeatedly. And to just, again, to go back to an original point, nobody is pointing to me a better idea that is out there other than something that addresses our debt problem to get to 38 states. And if you want to use Article 5, you got to have that first beachhead. And it's not going to be, overturning Citizens United. It's just not going to be. You're not going to get to 38 states with that. And likewise, on the right, it's not going to be the repeal amendment where states can, overturn any federal law they don't like. It's not going to be that, right? It's going to be something that is not ideological as possible, that is addressing a timely issue, and that the polls show matter. And there is nothing else but a balanced budget amendment idea, or a debt limit, or a debt check. And so that's why I would urge the left to support this. Even if you disagree with it on the policy, if you agree with the use of Article 5, find me a better tactical way to do it. I mean, if you can make the case to me that some other idea out there is a more plausible vehicle to get to 38 states, make that case to me.
Your plan, the compact, basically, it's the progressive worst fear of a convention come true. It's basically a hijacked convention for a single issue, no open debate. I hear this all the time. We can't have a convention. The right wing will show up, take it over, and we'll get the short end of the stick. So basically, what you've done is created this vehicle so that it guarantees that that's the outcome. If that is a given, what is left for the progressives to fear about an open convention?
Well, first of all, I think you're mistaken on that, because do you view a ballot measure the same way? Right? I mean, a ballot measure has a prepackaged text, it has a particular policy. There isn't any debate other than what happens in the media, and you vote it up or down. And I think the left uses it just as much as the right. It's a vehicle that is ideologically neutral, and all a compact is a way of transforming Article 5 into that kind of process. It is not necessarily only a right-wing way of doing things. I mean, it is simply an instrument. Now, does it preclude having a wider Article 5 process? Absolutely not. I mean, the problem with the way that you're thinking about it, and there are folks on the right who think the same way too, by the way. They want to have a wide open process too. But you'll never get there if you don't make people comfortable with baby steps in a controlled experiment kind of way with Article 5. And all that the compact does is it closes down all of the uncertainties, tells you in advance what you're getting involved in, and then lets the process play out. And so if you want to ever have an open convention where you have freewheeling debate and hundreds of delegates and all that, you're not going to do that in the first time. I mean, it's not even going to be John Birch Society that's going to be your problem. People are going to look at you like, you want to do that? I mean, who the hell wants to do that? I mean, you've got to start incrementally. I think actually this is a lesson the right learned from the left. I mean, the story of the left is incremental change. It's not sweeping change, right? And so now I'm talking to you guys to go back to your own roots and recognize that constitutional amendments are serious business. Article 5 is serious business. Having a convention is serious business. Before you go hog wild with every imaginable form of democratic interaction happening at that, why not first channel it, treat it more like a ballot measure, make people comfortable with it, show it can be done in an orderly fashion, and make sure that the package, we're telling you in advance what the package is. I think we've been reasonable, and I have yet to hear a serious critique from the left that opposes it. I've actually reached out to Brookings Institute, haven't heard boo. I've talked to Third Wave. I've talked to Concord Coalition, which may be more center. But I haven't gotten any serious critique from the left, other than they don't like the word balanced budget amendment because that sounds partisan or something, right? But the bottom line is this: you know in advance what the package is. Why do you care what the vehicle is? If the vehicle tends to legitimize the process and incrementally moves people to a comfort zone where you can do whatever you want to do next with Article 5.
You know, let's talk about that revision of the balanced budget amendment real quick. I've got some questions about how we hold the president accountable, basically, for the failures of Congress. Excuse me. And what happens if there's no budget, like we've had for the last 3 years? Does it put the president at risk of being impeached, or?
The problem is it's been 4 years without a budget, and that's because there's no mechanism to incentivize creating a budget. The difference with because under our balanced budget amendment, you don't get any increase in the federal debt without state approval. We believe that will strongly incentivize the creation of a budget because you're going to have to make a plausible case that can persuade 26 state legislatures. That means over 3,500 individuals to support more federal debt. And I don't think you're going to be able to do that by saying, "Hey, trust us. We're going to wing it for another year." I mean, what you're going to see is that is going to incentivize the creation of a serious budget that can persuade. And here's the reason why this is such a non-ideological thing. I mean, we're not saying don't use debt. We're just saying if you're going to use debt, make sure you can persuade at least half the nation. Make sure you can persuade the institutions that are closest to the people. Do it in a way that, and if you can't, then you don't deserve the debt. Because we're all in the hawk together. I mean, I keep hearing that from the president, that we're all in it together. Well, there's nothing more true about that than when you're talking about the federal debt. So from my perspective, how do we incentivize good behavior? Well, you usually appeal to their worst nature. Look, these politicians, they want debt. Here's how you get it. You make a case that you can persuade 26 state legislatures. Show me how you do that without a budget. You can't.
Let's see. Let's go back to the tally of the state applications. You're talking about hundreds of years of applications, dusty old applications. Your group, Goldwater Institute, Compact for America, took a look at all the applications, I assume, at some point. And what count do you come up with for applications? How close to the 34 state mark are we, according to your group?
Actually, we're trying not to count those because I don't think enough of them are sufficiently identical to really make a hill of beans. And to be blunt, none of them carry any contemporaneous current political will. Even if 30 years ago we had 15 applications that were identical, I wouldn't want to advance those dusty old applications because you know what? I pile them on a desk next to 19 new ones, and all Congress is going to see is 19 new ones, and it's not going to do anything. So to be blunt with you, the Compact for America is starting from ground zero. We are not relying on any existing applications. And it's not, part of it is that I don't think they're sufficiently similar, but more importantly, we don't think there's any political will manifested in those. We want to manifest real, tangible, contemporaneous political will because in the end, I think that's the only thing that keeps Congress honest.
To me, that seems like construction. You're creating new hurdles for Article 5, these applications, when it specifically, it doesn't even mention amendments until, in that clause, until the convention is called. The applications are just applications, and that the suggestion for the amendment is just a suggestion with no real legal effect. And we're obviously held to the laws of our forefathers and past generations. Why wouldn't we be held to the applications? Why couldn't we count those?
I mean, again, there is what is and there is what ought to be. I don't necessarily agree with your interpretation of the word application, but even if I did, history shows it's meaningless. Look, there are hundreds and hundreds of applications out there. They haven't motivated Congress to do anything. So if your legal analysis were correct, I would still say, how many divisions do you have, to quote Stalin or something? I mean, the reality is there's no political will manifested in a open convention type application. Not contemporaneously, not even, certainly not that are 50, 100 years old. What you have to do, as with all of politics, is you have to manifest contemporaneous, meaningful political will that means something to the careers of the people, the creatures that populate Congress. If you can't do that, you're not going to get a reaction out of them that is reliable. You might sometimes, I suppose it's possible that, you might get lucky that, simple majorities of Congress will do the principled thing, but you don't usually get to Congress because you do the principled thing. You do usually get to Congress at the near pinnacle of your political career, and that usually has involved some craven self-advancement. And so, I hate to say it, I like the founders' fundamental point of view, which is you balance ambition against ambition. You take, man's worst nature and you make sure that it's channeled to do the right thing. And in that same spirit, what I would like to do with the compact or any Article 5 movement is make sure that we manifest contemporaneous political will that actually wields a real carrot and a real stick for those people who stand in our way in Congress, because in the end they do have to call the convention. They do have to refer out the amendment. So, we can debate the theory if you want to. I'll debate the theory with you, but I'm trying to get past that. See, the whole idea of the compact is that we've banged our heads against the wall for too long. We've pretended like we could have these Dungeons and Dragons type, meetings about what the real meaning of Article 5 is, as if that mattered. It doesn't matter. What matters is whether you can manifest political will that means something. And there's no other way to do it than a compact. There just isn't. Nothing else manifests meaningful political will in a quick period of time that will motivate the folks that populate Washington.
I got to go back just because we've got it on our website. We counted 42 what looks to us as legal standing applications. Actually, we took the Judge Tom Brennan's view of these applications and how they count up what makes them valid legal standing applications, and we've got 42 states counted up, and we've got the actual applications. We don't want to debate theory either. We're looking at the black and white images from the Congressional record. And in most of these, it says that this application will be a standing and continuing application until 2/3 of the states have called for this. Does that clause, even with that clause where it even states in there's no sunset clause, this is a continuing application for an Article 5 convention, that also, you would say, we can't be held to that standard?
Well, no. Remember, you got two debates going on. Right now you want my legal theory response, and here's my legal theory response. You're not going to like what I'm about to tell you.
That's okay.
Look, here's the problem with the theory that non-identical applications can be tallied together under Article 5. It's a very, very, I think, to me, irrefutable legal argument, and it's this. Federalist 85 says that Congress's power is preemptory. That's the words that Alexander Hamilton used. Now, preemptory at the time was a name given to a kind of writ. A writ is a petition that you could file in court. An example of a preemptory writ would be mandamus. But the characteristic of the act that is preemptory is that it must be ministerial in its nature. It cannot involve judgment. It cannot involve discretion. It cannot involve policy determinations. And so here's the fundamental problem you have with asking Congress to tally up non-identical applications. You, on the one hand, are saying that Congress's duty is ministerial, non-discretionary, and non-policy based. And on the other hand, you want them to have the discretion, the policy judgment, and the freedom to decide what is close enough, what isn't close enough, what are magic words, what are not. And you can't have it both ways. I mean, either Congress has a ministerial duty where it acts like a robot, you feed it, identical applications and it spits out a call, or you have Congress having discretion and policy judgment, and you feed them a bunch of different applications of different language, and you say, well, now you got to figure it out and then render a call based on your judgment. You can't have it both ways. And so, my legal judgment is founders meant for Congress to have a ministerial, non-judgmental, non-policy-based role. And because of that, of necessity, our applications have to be near identical, so that what Congress does is basically robotic. If you throw a whole bunch of stuff up at Congress and they're not identical, you're asking Congress to exercise judgment and discretion that it doesn't have, and you're opening the door to them sitting on it and not doing anything.
Well, I honestly, I don't see where it says anywhere where the applications have to be identical, received within a 20-year period or anything like that. Again, it seems like there's more criteria being added on to these applications than what is laid out there. In Federalist 85, again, it says that there's not even supposed to be any debate over this particular thing. So counting up the applications, you can debate whether they're actual or not. But if you take away the debate, you're just counting. So to me, I look at that Federalist 85 argument, and it seems to me that they don't have the choice to really say, this is a good application, this is a bad application. It seems to me that the only role that they have is just, has this requirement been met? But is there any case that says it has to be identical amendments?
Not yet, no. And the problem with your hope that non-identical applications will be counted together is that you're asking Congress to decide what is an application, what is not an application, what language triggers Article 5, what language doesn't. Congress doesn't have that discretion if you think it's ministerial. Congress only has the ability of adding, and to add like a computer, and to add like a robot. And so I don't think the best interpretation of a shall call clause against a backdrop where the founders say that this is a preemptory duty, I don't think the best interpretation of that is that you can lob at Congress a whole bunch of things which only have one thing in common, which is that they cite Article 5, and say that they're supposed to count that up. I don't think that's a reasonable legal argument. I think a better legal argument would be to say, look, Congress's job is ministerial. Therefore, we have to treat them like they're acting ministerially, and that means we give Congress something that they have no way to interpret other than being an Article 5 application. And that has never yet been done. Unfortunately, there has just never been a set of 34 identical applications. The closest thing to it was during the repeal of the advancing of what would become the 17th Amendment, which was allowing popular election of the senators. There was a coordinated effort over 20 years, and almost all the applications are near identical. And I think they got within 2 states of the threshold, and then Congress jumped. And that's a lesson for us to all follow. Is Congress saw that that there were near identical applications coming after it, and Congress moved. And that's so I think as the legal theory, I don't buy the legal theory that we can say Congress's duty is ministerial, but they have the judgment to decide when things that look really different are the same. I don't think we can make that as a plausible legal argument. But even if we could, history shows that the only time we've ever been really successful with Article 5 is when we did have near identical applications. And so I say, make them near identical. And then even put that aside. And again, I'm going back to my practical argument. Even if you were right, 100%, if you had 18 letters from James Madison to all the other founders making exactly your point,
yep.
Where's it getting us? I mean, it's not getting us anywhere, and that's because in the end, it's about politics.
Yeah, I've seen Larry Lessig on television talking about how the amendments or the applications would add together. You guys are definitely coming from different viewpoints there, and it's hard to say what is right. but going back to that campaign with Woodrow Wilson for the 17th Amendment, even states like Wisconsin and Wyoming, in their applications, went ahead and counted the other states. At the time, it took 31 states to reach the 2/3 threshold, and Wisconsin, I think they counted up 37 or 38 states with the identical amendment. So if they're going to deny identical amendments, and technically they didn't call a convention, they caved in and passed the amendment that was close to what they were requesting, but it wasn't exactly what they were requesting. Even with those similar applications and passing the threshold, it seems like we're still due for a convention for 100 years, basically, from that action, but Congress decided to take another route. Are you fairly confident they won't do that this time, that they will call a convention and instead of caving in and passing your amendment and sending it out to the states?
Well, no, I think that probably the smartest move that Congress would make would be to preempt the compact and neutralize it because of the structural threat that one successful use of Article 5 would pose to their power base. I view that as a real problem, which is why, keep in mind, there are two parts to the compact. There's the congressional resolution and then there's the compact. And you can move on the congressional resolution first. You don't have to wait for the compact to get to the magic numbers. You can actually look for an opening in Congress if you find simple majorities and get that passed. And so what I would like to do to avoid that possibility is, my preference for tactics would be if we could pass the congressional component first, quickly, before the compact. I think I'd rather do that because that would lock down Congress in support of the compact, and I think make it politically difficult for them to then try to later circumvent it. I think it will make it more difficult for them to do that because they'll be committed to the process. So what I want to do is I want to use a compact and not only look for a confrontation with Congress, but I want to be able to use the flexibility of the compact to come to Congress when the opening exists. I mean, there will occasionally be openings with simple majorities in Congress to get things like this done. And that my preference would be to go to Congress first or in the middle rather than wait to the end when Congress sees the freight train coming. I'd rather them feel safe and not so worried, debate it more theoretically, pass it, and then go back to the states and get it done.
Yeah.
I really want to emphasize this. See, the problem with all the other Article 5 processes is you're coming after Congress. Even if you count up 42 or 100 or 3,000 or whatever, you're coming to Congress when Congress is now clearly aware of the fact that it's about to give up its power, right? All right. I mean, come on. How many politicians are confronted that way, effectively, right? A better way to confront a politician is to do it before they see that they're about to lose their power, right? You can't do that except through the compact vehicle. See, because otherwise you have no other choice but to provoke this clash. With a compact vehicle, you can give them a vehicle for running their campaign at a time when it doesn't actually threaten their power.
I've been wondering too, is the group going to keep everybody posted as to how many states have joined the compact, or are you going to do a reveal later on telling everybody we've already got X states on board, we're just about wrapped up, or are you going to keep us posted throughout the whole thing?
Of course, you got to build momentum. We need the grassroots. We need the progressives on our side. Look, if you hate balanced budget amendments, if you just want unlimited debt, you want to borrow from all future generations, and you just don't care, even if that's what you believe, you got to want to try this out because there's no other idea that can get us to the Article 5 convention. There's just no other idea. So join us. But apart from that, look, one of the great features of the compact is we create a commission as soon as we have 2 states in it. And the commission is a public body that has the job of going around the nation and organizing and notifying and getting everyone aware that this is happening. Just like, one of the things that Rob Nadelson, one of the guys who reignited Article 5 a couple years ago in some articles we published, one of the things he pointed out is that before you ever had the original Constitutional Convention, there were letters of correspondence, there were groups, there were prior conventions or prior meetings or there was a coordinating body. You got to replicate that, and so built into the compact is a commission that serves that function, that serves the function of riding around like Paul Revere. Here comes the compact. Will you join the compact? And so no, this is not secretive. This is nothing on this scale can be secretive. This is the sort of thing where we're pushing a wheelbarrow. We're hoping frogs start jumping in. When they start seeing other frogs jump in, they all start jumping.
And you would not mind if we got, because honestly, I'll just say I of course want to have an open convention. I think that's our mission as a group is to see that come about. So having this predetermined outcome coming up, we would want to create enough controversy, I would hope, to open that process up to everybody, put enough political pressure on Congress to free the delegates, I guess, from the compact agreement. But it doesn't sound like that's going to be very possible by the way that you guys have set it up here. But of course, that's the way we would want to see it. We want to see everybody's ideas hashed out, and of course, we would like to see your amendment too debated openly. Does the compact allow you to debate the language of the balanced budget amendment that you've revised?
Oh yeah, you can debate it, but you can't amend it. Again, the way to think about it is it's like a ballot measure. Everybody who passes the compact, just like anybody who goes into the ballot box and pulls a lever for a ballot measure, is giving their up or down vote to the whole process. The process is designed to prepackage the text so that everyone knows going in advance what they're getting into. The convention is one where there will be debate. The debate subject will simply be, do we propose this or not? And we anticipate that if you got 38 states in the compact already, that will decide the outcome fairly. But again, this is not some cabal any more than a ballot measure is. This is no different than putting a constitutional amendment under your state constitution on a ballot measure. That's all it is. And if you want to have a wide open convention, good luck with that. If you think you're going to do that, it's the first move that ever happens under Article 5. The powers that be won't let it happen. The John Birch Society and Eagle Forums and Phyllis Schlafly's ghost won't let that happen. It won't happen. So even if you ultimately want to get to some sort of open convention where any and all constitutional amendment ideas are proposed, you got to have a trial run that's less than that. Show me that the Wright brothers started with a V2 rocket, and I'll concede. But again, there's got to be baby steps. There's got to be an incremental process if you're going to ultimately end there. I'm ambivalent about having an open convention. I don't know why. I mean, I don't think anything would get done myself. I think it would be a nice, be kind of like a Woodstock for would-be politicians. I don't.
Kind of, yeah.
I don't know. I get that every day at work. I mean,
yeah, I've had these conversations with Bill Walker too, and we both agree that probably the biggest frustration to come from a convention is that very little will be done. Maybe 2 or 3 amendments may get passed, and the frustration will come not from what they've done, but what they haven't done, and that seems to be a little bit more plausible to me too.
Yeah. So I personally, in terms of having if 34 states got together and just said let's have a convention to debate any and all amendments, I'm not. That's not my bag. I just don't see that as a wise use of my time or life or resources. I don't think enough value would come of that. But I don't think it would hurt either. I think it would be valuable to create that sort of decentralization of power. But I'm just me, and there's only just you and a few other people who believe that. In the end, you've got to be able to pack a committee with more warm bodies who are willing to scream and cry as much as those who see that as the end of the world. And I don't think you're going to do that ever. And so you've got to devise something that is more controlled, more targeted, more limited, Otherwise, Article 5 will just be a pipe dream.
Yeah, if we had, when I look at the record of applications, when I discovered the list, I ran and I noticed there's enough states that have already applied for balanced budget amendment. Line item veto, I think, came pretty close too. And it seemed to me like, boy, this should have already been triggered. Why aren't they just, beating this and beating the drum and trying to raise awareness that they've already done this? Of course, I'm progressive, so I don't have an amendment that's been applied for by 38 states or 39 states, so I don't have the same kind of perspective that you do. It may look like a controlled experiment almost to have the first Article 5 convention with a very controlled environment, but for me, as a progressive, I kind of look at these things and think, well, geez, this is basically our worst nightmare, because we want to talk about a lot of things. And let's say, for instance, Rick Scott, you've got governors lined up as delegates in the compact. What if he decides to bring up the idea of eliminating the Electoral College? I don't think he has any support for that, but what happens to the convention once another issue is brought up?
The moment that a delegate violates his authority, he loses all power, is recalled to his state capital, and if any action is taken on that by the state's representatives, it disqualifies the state vote. And if the convention acts on it, then all the states in the compact are locked down and prevented from ratifying anything at all generated by the compact, and all we need is 13 of those to stick to block it. So it would basically implode the whole convention by design. Now, my perspective is this: if you think of this as a ballot measure, not everything has to be a wide open convention for the kinds of constitutional reforms that you may want on your side of the spectrum. Not everything has to be that, I don't see any reason why the compact would exclude the possibility or make it more remote than it already is that you would get a wide open convention. I think it would make it less remote because it would validate Article 5 itself as something that's useful. So I just, unless you're against, do you oppose ballot measures because they're not wide open too? I don't understand. To me, I don't understand the critique. It doesn't make sense to me. There's many ways to skin a cat. You don't have to always have a free-for-all to amend a constitution, right? You can also do it in targeted ways. And I don't see you guys saying let's redo the entire, rather than using ballot measures in California, let's just have a giant wide open convention. In fact, I'll fight you to the death if you dare use a ballot measure. Come on.
Well, yeah, there's definitely. I think it's probably the fact that it's just one ballot measure. If it were a couple of different things, and Article 5 does specifically say amendments in the plural.
This is not one. This is wait. This is not one. This is the first use, right? There's nothing about the compact that says there can't be future compacts. This is proof of concept. That's all it is.
Right. Yeah, it's definitely, it's got us scratching our heads, honestly, to try to figure out how we get into this, because this is a method that the conservatives have taken a look at for decades. And honestly, I was never taught about Article 5 in school, college. It wasn't until the Citizens United ruling that made me actually pick up the Constitution and read how to amend it that I actually discovered the convention process. So it's one of those things that we're just not well exposed to it, quite like the conservatives are. It's not surprising to me that you guys are making inroads in this kind of an effort before we are, because the progressives have just rejected it, and I think that we're kind of new, at least on this side of the aisle, to that kind of a process, and it's definitely obvious through the past decades that, especially during the 60s and 80s, that there have been so many efforts on so many different fronts to amend using this kind of method, but they're all basically conservative ideas. This is something that we have to begin to embrace as progressives and learn more about it, and hopefully we can learn to use the tools that you've figured out for everybody else. And we're a bit farther away, though, because we don't have those past state applications quite like you folks do, and so we're going to have to catch up. We're definitely going to have to catch up and try to consolidate ideas. When I talked about this idea, when I first heard about it with one of my friends, that it'd be so hard for the progressives to agree on the language of an amendment ahead of time, because it's just a difference of basically who we are. It said that progressives like meetings and conservatives like leaders, and you are definitely providing leadership.
But Dan, that's not true. I mean, you do all kinds of ballot measures. I mean, come on. I mean,
no, that's true. But I mean, with this particular effort.
Yeah, but I mean, you guys are looking at this. Look, I don't want to. I'd rather you guys continue to scratch your heads and not use this and just jump on board with us. I mean, I'd rather have that. But come on, you guys create ballot measures all the time. Constitutional amendment ballot measures all the time in the states. You can't tell me you can't figure out a text that you would run. You can. You know how to do that. Look,
Sure.
This is not a right-wing cabal. This is not a one-way, one-time vehicle. This is a vehicle that anybody can use. The only long-term effect it will have is the decentralization of power. It will make sure that if there is a captured power base in Washington, it will forever be contestable, which is, I think, something that anyone who's a human being who doesn't like tyranny would want, regardless of whether you're on the left or right, right? So that's why I think you guys should support this sort of vehicle. It makes power in Washington infinitely contestable forever. And so if you want to have your open convention, you go ahead, do that. This is a different thing. This is a totally different vehicle. This is meant to be like a ballot measure. You don't go in California and say, I'm never going to vote for a ballot measure because, gosh, I just want to have a wide open convention and we'll redo our state constitution and that's the only way I want to go. Come on, that's not what you do. You engage on the vehicle. The vehicle you can agree on. You should be agreeing on this vehicle. You should want to see it succeed. You should respect the fact that we've chosen a payload that is not, you shouldn't offend your sensibilities in any dramatic way. We've designed it not to. And then you should recognize that if you're ever going to get to use the vehicle, it's got to be something that can get to 38 states.
Right. Well, I definitely support your efforts to present this in a convention setting, and hopefully we'll see some action on it. Hopefully we'll see some debate. I would definitely love to see more public awareness of what you're doing, and hopefully we do see. I really see this too as getting back to Citizens United as a whole new political marketplace of ideas on a constitutional level. You've created a vehicle for each one of these amendment groups to plug themselves into it, and we've now actually got an ability to effectively deal with constitutional issues and amendments, and for that alone, again, I admire your plan, and I hope it does spark, it kind of bring the Constitution back to life, to a living, breathing document again, one that definitely responds to the needs of our time. And you might be onto something. Again, I think you're going to run into some resistance just with the name balanced budget amendment from the progressives, but but I think that it is a very honest attempt at trying to find some middle ground, and I do wish you luck with all of that, and we hope that the Article 5 process does become a tool that that everybody takes a look at and hopes to use in some fashion. So thanks for joining me here. This is getting